afternoon. My name is Kweku Darfoor of the Darfour Law Firm. I'm a personal injury attorney down here in Fort Lauderdale. Our main office is in Fort Lauderdale. We practice statewide in personal injury, and we have a satellite office that's also located in Boynton Beach, Florida. Today, I wanted to discuss with you attractive nuisance doctrine and what it means, especially in light that the summer is here now, and a lot of us are going to be enjoying time at the pool, and there's going to be a lot of children around, most likely. So what does that mean, and how can you be impacted as a homeowner, and what safety measures can you take? Stay tuned, because I will be discussing that with you today. So you're probably wondering, well, what does this attractive nuisance mean, right? What's the definition? So an attractive nuisance, essentially in tort law, it's a tort law concept which will hold homeowners liable for injuries that are caused on their property to a child. And then there's some other concepts around it, right? It's something where it will cause injury to a child, and with which it's like an object on your property which is likely to attract children to it, and then eventually causes an injury to them. So that is the definition there. A couple of examples for you to kind of just grasp your mind around this are like pools that are left unattended with no fence protecting it, right? Like if you own a pool in Florida, at least, there's laws, statutes, rules that mandate that you have to have some kind of protective measure around it. And if you leave it open and a child comes on there, well, you may have a big problem on your hand. Other things may be, dishwashers, fridges, refrigerators, freezers, abandoned cars, trampolines, things of that nature that a child cannot grasp the concept of danger. There are some of those, examples that you should consider or that you can grasp around what to look for, right? Now, there are certain requirements in order for somebody to be able to bring an attractive nuisance claim against you, and I want to go over those with you, right? Oftentimes, you think, well, I did all I could. Well, sometimes you don't do enough, right? The first element really, or the first, I would say, condition is that it has to be a dangerous condition, right? There must be a dangerous condition that's present on the property, and that you can think of a million things probably that can be dangerous conditions on the property, right? The second thing is that the owner must know about it. The owner must know about the dangerous condition, or they should know about it, right? Like it's something that they should know about because they own the home, and they should know that there's a dangerous condition on the property, and the possibility that children may actually trespass onto the property. That's the second condition. The third one is that the child's understanding must be so that the child cannot appreciate the dangers or the risks associated with that property or that object on the property. They can't really grasp the concept of like getting injured. So in Florida and other jurisdictions, usually a child under 7 years old is not to be able to be negligent, right? They don't appreciate the risks of that. A child between 7 to 14 is usually going to be presumed that they can't be negligent, but that presumption can be overcome, right? Based on that specific child and the awareness and so forth. But 7 to 14 is going to be presumed that the child can't be negligent, and then over 14, it doesn't apply. Right? Over 14, you should be able to make these decisions, and you're aware, you have some awareness, you're more mature and so forth, right? So that's the third one, right? The fourth one is a child trespasser. The child has to be trespassing on the property. So it can't be an invited guest, right? Somebody that you had over, maybe brought the family over, or someone that is being babysat or something. It has to be a trespasser, someone that you weren't aware would come onto the property. So that's the fourth condition, and that's because an attractive nuisance they don't want to have the same standard as just a regular negligence to a child. An attractive nuisance has to be somebody that you're not even aware is on there, but there's some danger that attracted them and posed a risk to them, right? Now the fifth condition is that the likelihood of injury is there, and the remedy would be to fix it, and it's a slight maybe expense or a slight thing to do to fix it, but you don't do it, right? So if it's just, let's say, putting a fence around, which would maybe cost a couple $100, and you choose to not do it, well, there was no reasonable care there. So that's the fifth condition. And all those have to be met in order for you to be able to be held liable under the attractive nuisance doctrine. Now, there's some things that you can do to prevent this kind of claim from being brought forward. So if you follow all the regulations and rules regarding, for instance, a pool, you keep it safe, it's secured, and so forth, there's safety measures, you could at least insulate yourself from liability from just having that. If you lock something up and it's locked and it's hidden and it's, secured like a car, and it's not like open and obvious to the child, like they can see it, like if it's wrapped or something, you may be able to protect yourself there. So there's some things that you can do to protect yourself. Now, the last thing I wanted to discuss is comparing what's the attractive nuisance doctrine to trespassing, right? So many people might believe that if someone's a trespasser, well, it absolves the property owner from any liability. However, this is not the case. So if someone is between the age of 0 and 7 and they're trespassing laws generally don't apply to them. Again, between 7 to 14, it's going to be held at that age range. A child cannot be negligent, so trespassing laws, usually won't apply to them either. So just because somebody is trespassing on your property does not mean that you are absolved of an attractive nuisance claim that could be brought against you. Again, my name is Kweku Darfoor, and I practice personal injury throughout the state of Florida. If you found that today's video was of value to you, or you found something that could be helpful to you, please go ahead and hit the subscribe button below. The subscribe button will allow you to be a subscriber, and also hit the alert button. The alert button down there will notify you of new videos that we put up that could be helpful to you. And finally, if you think that you have a case that we may be able to assist you with, please feel free to give the office a call or shoot us an email.